Happy Friday, everyone. Welcome to Conversations Care on Caring, our Facebook talk show where we bring together our healthcare partners, our clients, and our caregivers to help families better understand and cope with aging parents with chronic care needs. My name is Julie Collada, and I am the proud founder and president of Open Arms Solutions. And Open Arms is a home care agency serving the Chicagoland area. We're focused on uh, inspired home care solutions for seniors with chronic conditions such as dementia, Parkinson's, and other movement disorders. It is truly our mission to help our families through this journey and to know that their loved one is living their best life possible. If you find this information helpful, please give us a like and share, and so more people can receive this information. And if you have a question or topic you'd like us to cover, please write it in the comments section, and we'll put it in our list of topics in the future. With me today is my good friend, Matt Margolis. We've known each other, I feel like, so long, Matt, from Margolis Weldon, to discuss the really important topic of the basics of estate planning. Hi, Matt. How are you?
Hey, I'm good. How are you?
I'm doing really well. Great to have you on our show. Matt, I think you were one of the first people so we're in our 15th year, like in a blink of an eye, we're in our 15th year at Open Arms. And I think I met you pretty early on in the
Pretty
start.
close. Pretty close, yeah, because I've been doing this for a little over 11 years now.
Yeah.
And so, maybe in that fourth year then of Open Arms is when we met.
Yeah, I think that's about right. And look at you now. So
Here we are.
Here we are. So Matt is one of the partners at Margolis Weldon. And, Matt and his partner Lauren do a wonderful job advising seniors on incredibly important topics and estate planning. I know you also do Medicaid planning. Let's talk a little bit and just let everyone get to know you a little bit better.
Sure.
What caused you? What was your journey? How did you arrive at becoming an estate planning attorney?
So I don't. Mine's probably different than others, but we all have our own story. So, when I was in law school, actually, if I even go before that, so when I was in junior high, I knew I wanted to be a lawyer. I had two uncles that were successful attorneys, and from a young age, I was looking at them and being like, wow, they're able to support their families and they're helping people. And so from then I just kind of wanted to be a lawyer. But then when I got to law school, I always knew that I wanted to help people and I wanted to make money.
Yep.
And when I got out of law school, I was doing one of those things, and that was helping people, but I wasn't really making any money, and that was okay. And I was working for an attorney, basically doing everything and anything under the sun. Whatever came my way, that's what I did. And I did that for about a year and a half, living at home with my parents in Skokie, making just enough money to kind of hang out with my friends on weekends and not even pay back my loans. And one day I realized that I needed to get a job, like a real lawyer job. And I responded to a Craigslist ad that an attorney had posted, and didn't really know the type of law they did. Ended up going in on the interview, realized it was estate planning and elder law. And as a then 27-year-old, to be honest, I was thinking, there's no way I'm going to do this. This would be so boring. Estate planning and in my head at the time, working with older people. But I ended up getting the job offer. I took the job. It was in the suburbs, and I wasn't going downtown anymore. And I'll tell you, within 3 months, I realized that was my calling, and that was the job for me. And I think part of it was that I grew up with an older dad. My dad's still around, thankfully. But I'll give you some perspective. I'm 38. My dad's 89 years old. My dad will be 90 this summer.
Wow.
And so I think I've always sort of had this, without really knowing it, this compassion and sort of empathy for older individuals. And
Hmm.
that was it. I mean, I never took a wills and estates course in law school. It was something, again, that was so far from anything I thought I would ever do. But here I am. I've been in this area of the law now for 11 years. And Lauren and I started our practice 7 years ago, a little over 7 years ago at this point. And this I have zero interest in doing anything else.
And it's well, thank you. I learned some new things about you. I didn't know that entire story, so thank you
Yeah,
for sharing it.
sure, sure.
And for so many of us that are in the field for providing support to seniors, um, you get hooked. As you just
Yeah,
described. It is an amazing feeling to know that you fulfilled such an important role in their lives, a crucial role for the whole family. So
for
that's
sure.
great. Thank you for sharing that.
Yeah, of course, of course.
So the title of this talk is, I think, Estate Planning 101. Estate Planning is not just for the Pritzkers, which I thought was just a great title. So let's just start out by having a conversation. What is estate planning?
Yeah. So, I mean, everybody has an estate, right? And it's what's funny is, and I'm sure you hear different versions of this. People will sit down with people, and everybody has, and some people will come up with these comments like, "Oh, I really don't have an estate," or I have nothing, or I have very little, or and I always love when people say they have very little, and they're worth a couple $1 million, but they have very little because their neighbors have multi-million, tons of millions of dollars, right? And so everybody has an estate, and I don't care if you have $30,000 in the bank or $10 million, right? The reality is that we all have something, and most of us have had to work for it. A very small percentage of the population has been given a handout from a grandparent or a parent or somebody else, and so it's important to plan. I mean, most of us care about what happens with our stuff when we pass away. I've met very few people over the years, and doing this for 11 years, easily a couple thousand clients. I can honestly think of probably less than five people that have had kind of like a very blasé attitude when it comes to what happens with their stuff when they're gone. And those have tended to be single or widowed individuals that don't have any children and just have sort of a negative outlook on life. And that's pretty uncommon, pretty uncommon as far as, the people we normally meet with. And so really, to me, estate planning is planning your estate, planning for what's going to happen when you pass away. But it's even more than that, because estate planning includes planning for what happens when you're alive, but maybe not doing that well. All of a sudden you've been diagnosed with something. Maybe it's a chronic illness. Maybe it's something that's something that hopefully you're only going to deal with for a couple of years, but it could be chronic. And so, the idea is really putting some sort of plan in place. And there really is a plan for everybody. I don't, obviously I'm a little bit biased, but everybody needs some sort of a plan, and it doesn't need to have all the bells and whistles. But again, most of us care about what's going to happen with our stuff. And most of us care a lot about how we're going to be taken care of during our lifetime in the event that we become ill. And we can't take care of ourselves anymore. And so it's really just about making sure that we've got the right documents in place, because at the end of the day, all of this comes down to legal paperwork, right? I mean, in your industry that if somebody's incapacitated, you're working through a power of attorney. If somebody can't make their own medical decisions, the healthcare power of attorney has to step in and make decisions for them. So again, it's not just planning for death, it's planning for what happens during our lifetime.
During our lifetimes. Yeah. Well said. And yeah, and you and I see, this next question kind of, when do you think people need to start to think about an estate plan? Because in our industry, we have the same, I'm imagining the same experience, that all too often people come to us when there's an event or there's a crisis. And then we we respond best we can to that crisis. But ideally, from an estate planning perspective, when should people start thinking about it?
So, and I agree with everything you just said, Julie, because we do work with so many people that are in crisis, and just in general, right? This isn't an epiphany, but as we wait and as potential crises occur, our options decrease, and sometimes we have very few options. And so, the idea of when to start planning is sort of a tough question to answer, but it's a question that comes up very often. There's sort of, in my opinion, we're going to have different stages of when to plan, right? And everybody's going to plan at different times, obviously, but sort of what's ideal or what's typical, because I almost want to say what's typical versus what's ideal, because if we say what's ideal, I think the answer is, well, you're being realistic, you're mid to late 20s, you're established and hopefully in some respect, maybe it's not your forever job or forever career, but you've graduated from college, or you haven't graduated and you're working, and maybe you've started a family and maybe you haven't, but you're young enough and healthy enough where putting something together makes sense. And if nothing else, maybe that's just putting powers of attorney in place. Because we could become incapacitated at any point in time. We could be in a car accident tomorrow and not have the ability to make our own decisions. We put powers of attorney together for 18-year-olds going off to college, which is something a lot of people don't consider. So we could argue that you could start planning at that point, because once we all turn 18, we become the only person in the world that can make our own decisions. But I will say, from a very realistic standpoint, when people ask me when should people really start to plan, I would say, for younger individuals, typically they're going to start planning when they start to have a family, right? So what's going to be more common, and what we would really advocate for, is that you're married or you have kids. In any case where you have kids, you should be planning, because now you're responsible for somebody else, and if something happens to you, we want to make sure that there's a guardian in place to take care of them, and a guardian that you've chosen, not leaving it up to chance, not having your parents and your spouse's parents in court fighting over who's going to take care of their grandchild. And so
it might make sense to just describe what a guardian is a little bit more for our viewers.
Yeah. So in Illinois, in many states, right? So anybody that's under the age of 18 needs a legal guardian. Okay. And in most cases, if they have biological parents, their biological parents are typically going to be their legal guardians. That's not going to be in every case, right? Obviously, in the case of an adoption, if I'm adopting somebody, I am their legal guardian, and their biological parent is no longer their legal guardian. And so the situation that I'm talking about is a situation where, if I pass away, my wife and I pass away, and our youngest child hasn't turned 18 yet, we need somebody to step in and be their legal guardian until they're 18. And so with a last will and testament is the document where we are going to name guardians for our minor children. But at the end of the day, I always tell clients this, and it's important to know this, it's a suggestion to the court. Okay, because if my wife and I name my brother to act as guardian, and then something happens to us, and at the time that a guardian needs to be appointed, my brother has an alcohol problem or a drug addiction, the court's going to have somebody interview him, and he may not be. They might not want to appoint him. And so it's always important to have maybe a couple people listed as guardians. Obviously, if we have a few people that we really know, like, and trust.
Yeah, that's some great advice. It's just, if you don't name that, though, and you don't have that documents, then you completely lose control over, right? The court then becomes the guardian.
Well, the court could become the guardian, but what would be more likely or more common is that if my wife and I passed away and either one of our kids were still under the age of 18, somebody would likely in our family petition the court. So somebody in our family would probably hire a lawyer and petition the court to be their guardian. And then the court obviously kind of goes through a process to determine, is this person a fit guardian? If my dad at 89 was petitioning the court to be the sole guardian of our kids, the court might not grant that, right? Because my dad means well, but at 89, he might really not be the best fit for them, especially if my mother-in-law is also maybe petitioning the court. And at 65, she's probably a lot more of a realistic guardian for them. And so in most cases, somebody will actually petition the court. But there are some situations where, families are don't get along. There aren't really that many people that would step forward. And then, yeah, and then the court would have to appoint a guardian, and then you're looking at, then you're looking at sort of like the foster system, and then that can kind of go down a different path.
Yes. Yep. Yep. Makes sense. So people need to start thinking about an estate plan, certainly when they have children. And interesting, from you talked about power of attorneys and how important they are. And those are legal. POAs are legal guardians. We not guardians, but appointed to be able to make decisions on behalf of someone else, and that's so important when we do. And how often we go in and talk to families, and that there are no POA documents. That's one of the first things we need to make sure are established, and try to explain to someone, if God forbid happens, and that person could no longer make these decisions, if there's not that power of attorney document, which is often part of an estate plan, right? That's part of the whole process that you take people through.
Yeah, it's pretty atypical for an estate plan to not include powers of attorney documents for healthcare and property. We see it. We have clients come to us where they worked with an attorney, and for some reason just a trust was put in place or just a will. Very uncommon. Very uncommon. And I've had clients come to us saying, "Oh, I just need a will or trust. I don't need powers of attorney." And we're pretty. I'll say that's one thing where we might be a little pushy, and we might say, this it's pretty. This is something. We needed to do all this together. And to me, powers of attorney are equally, if not more important than having a will or trust in place.
Yeah. Yes, it is. You mentioned one thing too. When my son, our youngest, Michael, went off to college, 18 years old, and I got a call, and he was in the emergency room. He broke his ankle. He was at University of Wisconsin Healthcare Systems hospitals, and I needed to talk to them about Michael, but there was no POA in place. So you had mentioned, and this is just a great, and I've told all my friends about this, because we don't think about, when your child is now 18, the healthcare system will not talk to you unless you're the POA. So right. Those are kind of the things that you have to just think about that most people don't think about.
Right. And I get it. And when it comes to a lot of this, people, it's not so much people not wanting to think about it. It's just people. It's just a lot of this stuff isn't on people. It's not on our radar, right? Absolutely. The average person, this just isn't on their radar, especially POAs, powers of attorney documents for an 18-year-old, because most people aren't even thinking about it for themselves. And so if they're not thinking about it for themselves, no way are they thinking about it for their now adult child.
A really good point.
Yeah.
We have a viewer question, so let me just see what this is. Who is your contact for planning? The named client, the POA named for financial, or a lawyer? So who do you typically sit down with? And that really, I think, feeds into the next question, kind of what are the steps needed to create an estate plan? So I think the viewer question is, who do you sit down with?
Well, for majority of people that we're doing some estate planning work for, I'll be sitting down with the actual client, right? So Julie, if you call me and you say, "Hey, Matt, so and so gave me your information, I need to do some estate planning, or my spouse and I need to do some estate planning." I mean, I'm sitting down with you, and if somebody's married, I really want to be sitting down with both spouses. I mean, in certain cases, maybe we'll only sit down with one if it's just the logistics of getting both spouses together is extremely difficult, but that's pretty few and far between. With older clients, it can be a little different. Some of my older clients, if they already have powers of attorney in place, and maybe we're discussing issues that are related to the planning, I can sit down and talk to the power of attorney. But at the end of the day, depending on any decisions that we make, it might have to go through the client directly. And that just really depends on the language in the power of attorney and what the power of attorney can or cannot do for for the principal, for the person who's planning we're doing. But in most cases, I'm sitting down with the actual client, and was the question sort of like what are the steps in the planning? Is that what you had asked?
The question was, oh, there's another one that popped up. Who's the contact for plan? Who is your
I mean,
contact? The named client or a
it
POA?
would, it would, so if my client is incapacitated, it would be the power of attorney if they have one. If the client is not incapacitated, it may still be the power of attorney if my client wants me to communicate through their power of attorney. If they have capacity, the power of attorney might still be in effect because a power of attorney can take effect the day it's signed. And so I could still work with the power of attorney in that case. But yeah, majority of the time it will be the client directly.
Okay, makes sense.
Yeah.
There's another viewer question here. This is a very common one. It's a great question. My parents never want to talk about estate planning with me. How do I break the ice?
So I found that in some cases, this viewer's parents in this case might have an easier time talking to a professional, talking directly to an attorney. In a lot of cases, they're more comfortable talking to the attorney about it than they are talking to their own kids. Some clients that we work with, they're just very secretive about they don't want their kids to know about their finances, whether they have a lot of money or not a lot of money, it doesn't really matter. They just don't want to share that information with their kids. And sometimes they also, I think that they do it from like a protective standpoint. I don't want to discuss my mortality with my children, right? It's like I can relate that with my parents. It's like every time they have a medical issue, they think they're helping me out by not telling me about it versus being open. And so I'm not saying it's right or wrong, but that might be a situation where maybe your parents are more comfortable talking to a lawyer. So I've told clients in the, adult children in the past that have reached out with that similar question. I said, maybe they'll contact, if they want to contact me directly, you don't have to be a part of it. Yeah, you're pushing them, and that might be kind of pushing them away from it. And so maybe it's sort of like, hey, listen, I'm done. I don't need to be involved, but here's the contact information for somebody that can help. And it's sort of like, if that doesn't work, I am not one to sell estate planning through fear by any means. That is not how we do business. However, I will say there's a time and place for it, right? So sometimes I'll have adult children, maybe you need to talk to your parents about the idea that, listen, you don't care who they meet with or what they do, but you don't want to be in a situation where all of a sudden they're incapacitated and a court is starting to make decisions for them as to who will be able to make their financial decisions, who will be making their medical decisions. At least if they are proactive about it, they get to decide. They get to choose who's going to step into all these roles and support them, as they get ill and when they pass away. That's probably the best answer I can give. I mean, I think it's
a really good answer in my opinion, Matt, because, we've had similar conversations with families, and it's like, I'm just concerned about mom, dad. If we don't have this information, I don't know what you're going to need or want. And right. I don't want to be put in a position where I make a choice that you wouldn't want. And so I, in my experience, that can be helpful. Not to everybody, but sometimes that can help, put something in perspective when it's really other things just, aren't flowing.
Right.
Let me make sure, because we're actually running out of time here, and there's so much other things to talk about. What are the steps needed to create an estate plan? What does that process look like? Yeah.
So, obviously I'm coming from our perspective and how we do things in our office. And, obviously people should understand that other attorneys work a little bit differently, but, typically, the first step with folks from an estate planning standpoint is we want to provide education. Most people don't know, even though we might get a call from somebody saying, hey, Matt, my financial advisor said I need a trust, or Joe Blow said I need a will. Most people have no idea between the difference between a will and a trust. Somebody's told them that they need this document. And so, our first step is education. And whether we're doing that through a one-on-one meeting with clients where we kind of go through, wills, trust, powers of attorney, HIPAAs, living wills, sort of all the documents that we feel makes up a pretty comprehensive estate plan. That first meeting is just going through all of that and giving them all that information, and it's totally educational. We also, I do an estate planning 101 Zoom talk, once a month, that sometimes it's easier for them to kind of tune in at night versus taking time out of the workday. And the information I give is exactly like I do in that first meeting. And so some people might do it that way. But either way, if somebody's going to work with us, they're going to do one of those. They're either going to have a one-on-one meeting or they're going to attend that talk. And then from there, we're going to determine what's the best plan for them, right? Let me understand what their goals are. Let's see what your specific circumstances look like. And then we'll make some suggestions about what we think an appropriate plan would be for them. And then obviously it's their choice. Do you want to go down this path, that path? Do you not want to work with me at all? And then typically from there, we start the process. And that's where, we'll have our clients sort of fill out a questionnaire and give us all the information that we need to draft the documents. And then from there, we'll sit down and we'll have a conversation. We'll go through that questionnaire, go through all the questions with them, make sure that we're on the same page, make sure we understand exactly what they want and exactly what they mean. And then once we're on the same page and we're speaking the same language, from there, we draft the documents, we get them to the clients to review, we go over any questions they have or changes they want to make, and then we're signing the documents, and then we're talking about, maybe next steps even from that point. If we have a trust in place, I know we're not going to get into the details of it, but if we have a trust in place, this is a document where we need to actually retitle our bank accounts and our investment accounts and our real estate. And so we're going to talk to the clients about, all right, now that you have this trust, you have to go do X, Y, and Z so that you're actually taking advantage of the trust. If there's any real estate, we'll help with that. So, for most people, once we kind of start the process, it's probably about a 3-month process, give or take a couple weeks. And then obviously we have outliers. I'm working with clients right now that have signed up with us in March of 2020, and we're still working on their estate plan by no fault of our own. So, that's sort of what the typical planning process looks like, at least for us.
Okay, great. Thanks for explaining that.
Yeah.
Just at a very high level,
Mm-hmm.
Because I know we don't have time to go into a real detailed explanation, but what's a trust? What's a will? Just high level, Matt.
So very, very high level. Okay.
Yeah.
So a will is both a will and a trust are documents that will talk about where our stuff goes when we die. Okay. Biggest difference between the two for most people out there will be avoiding probate or not. And probate is the court process where our estate can go through it and the judge determines where our stuff goes when we die. Okay. And so a will is likely a document that will still require our estate to go through probate. So we kind of look at a will as like a letter to the judge. Dear judge, my name's Matt. I passed away. Here's what I want to have happen. But it's going to have to go through the court system, right? The executor, who's going to be the person that's going to administer my estate, is going to hire a lawyer and is going to deal with that probate process. And in a pretty straightforward, simple, nobody's fighting probate estate, probably looking at a year to 24 months before it's all settled. And then everything will be distributed to the beneficiaries. Okay. Mm-hmm. A trust, okay, a revocable living trust, because there's different types of trusts out there, but the revocable living trust, which is the more common trust that we would draft for most people that are doing planning, this is going to do the same thing as a will. It's going to decide what happens with all of our stuff when we die. But the biggest difference is that a trust will allow us to avoid the probate process. It will allow us to avoid going to court. It's sort of like the idea of having a power of attorney versus not having a power of attorney and becoming incapacitated. I have a power of attorney. Well, the agent I named gets to deal with all of my stuff and take care of me on a private basis. If I don't have a power of attorney and I'm incapacitated, they're going through a guardianship, which is a court process, and it's going to take more time and cost more money. Same thing with a trust. The trust is like that power of attorney. It's going to avoid probate as long as we make sure we retitle our assets. And the trustee of the trust, which is sort of like the executor of a will, is going to be the person that's going to manage my estate and make sure that everything goes to the beneficiaries, but avoiding that process in court. So very high level, that's really the biggest distinction.
Yeah.
The one other thing I'd add really quickly is that for somebody that does have an estate like the Pritzkers, or, on a much smaller basis, but a nice size estate, trust can also help avoid estate taxes.
Very important. Yep. Well, Matt, I think we have your contact information in the comments. And I think that the first step, if people have questions or follow-up questions, is just to reach out to you with questions.
Yeah, for sure.
And, I really thank you for being part of this time with us. I know there is so much more to talk about. If viewers are interested in going into your monthly Zoom Can you just, I think Alex would be able to post it. How do they do that? What's the best way to do that?
The best thing, but honestly, I know my email's in the chat. They can just shoot me an email. It's the last Thursday evening of every month at 7:45. It's via Zoom, so people can email me, and I can always let them know when the next one is.
Perfect.
Yep.
Perfect. We're out of time. I told you it would go fast.
Yep.
Great to see you. We haven't seen each other for a long time. Great to see you. Thank you for the work you do and for being on the program.
Well, thanks for having me. Same with you, Julie.
Take good care.
You too. Bye.
Thank you. Bye-bye.